You are on bond for DWI, and you've now picked up a new DWI. Sir. You are charged again. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
All right, pause right here. This situation is already serious. The defendant was already out on bond for a DWI, and now he's facing another one. In the eyes of a judge, that's a huge red flag because bond is basically a promise to stay out of trouble while your case is pending. Break that promise and the judge can revoke your bond instantly. What do you think? Should someone get another chance here, or is jail the only option?
Thank you, Your Honor. On April 24th, 2025, in Harris County, Texas, law enforcement officers were dispatched to a crash. The law enforcement officer spoke with a complaining witness who stated he had gone to the bathroom and heard the defendant crash into the bus. The complaining witness was the bus driver. The complaining witness estimated the damages to be $1,000. Another witness saw the defendant strike the bus, get stuck between the bus and another vehicle, and then exit the driver's side door and try to push the vehicle out. The witness stated after another individual told the defendant they were calling the police, the defendant fled. Another law enforcement officer was alerted to the incident and found the defendant who matched the description given. A witness was able to identify the defendant as the individual driving the vehicle that struck the bus.
This part is important. A lot of people think refusing a breath test or sobriety test means there's no evidence. But that's not really how it works. If officers believe there's probable cause, they can request a blood warrant from a judge, which legally allows them to draw blood to test for alcohol or drugs. So refusing tests might slow things down, but it usually doesn't stop the investigation.
Another law enforcement officer made contact with the defendant who stated he was coming from an Astros game where he drank. The law enforcement officer observed a moderate odor of alcoholic beverage, glossy eyes, and profuse sweat from the defendant.
And there it is, the moment the whole hearing was heading toward. The judge revokes the bond, which means the defendant is going straight back into custody. Judges take repeat offenses while on bond extremely seriously because it suggests the person isn't following the court's conditions. Once that trust is broken, judges often feel they have no choice but to lock things down.
The defendant refused to cooperate on standard field sobriety tests. The defendant refused to provide a specimen. A blood warrant was obtained and executed.
Mr. Gallegos, I'm going to find that there's sufficient probable cause to go forward with the case. I am now taking away your privilege to drive. You are not allowed to drive at all. Do you understand me?
Yes, sir.
On one ankle, I'm going to put a scram monitor so I know you're not consuming alcohol. On your other ankle, you will get a GPS monitor, and I'm giving you a curfew because I don't want you out in the middle of the night. And if I find that you're out, I will revoke your bond and make it extremely high. He's on bond for this DWI.
Yes,
I'm
sir.
revoking his bond. You're going to jail today.
Right now?
Right now.
Okay, as far as the monitors, can we
So-
waive the fees?
Absolutely, of course.
Can you give my stuff to my mom?
Yes.
So these are conditions. We'll have him sign now. The GPS monitor prior to release.
Are you setting the bond through him?
Of course. Mr. Gallegos, I want you to understand something. This is an affidavit that you're going to sign to me, that you're going to promise to me you're not going to drive. I don't give a rat's behind what your excuse is. If Jesus comes from heaven and needed to ride to church, you drive. I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
That line from the judge might sound dramatic, but legally it's actually a serious warning. If the defendant drives after signing that affidavit, the judge can charge him with contempt of court, which is a separate violation that can bring additional jail time and fines. In other words, even one mistake after this point could stack new penalties on top of the original case.
I am now also sending notice to DPS that I'm placing a restriction on, you're not allowed to drive, but I'm placing an additional restriction on your license that you are not allowed to drive any vehicle that doesn't have an ignition interlock on it. This notice is sent to DPS so that every single officer in the state knows that if you are in a vehicle driving, they pull you over, you don't have an interlock, they will take you to jail. Do you understand? As it stands, you are not allowed to drive for any reason. Okay, we'll have him sign this. We'll put him in back. I'll set the bond and then,
Take my card here and
Look, you want to start moving around, we'll handle this when I do get the.
All right, Judge.
get whatever date you want on the new cases. When he posts bond on the, old case, feel free to get in touch with the, and then you can put the date
Just
for
one
whatever.
together.
Yeah,
what are
He-
you setting the bond at? I'll tell it.
5,001.
5,001.
Yeah.
Both cases or just the?
He just, no. The two new ones, I'm not gonna touch. I'm gonna leave it as is. He's made a bond, so we're only gonna do the old DWI, 5,001. Actually, we're gonna need, he signed conditions now, so when he gets out, he'll
I'll
have,
have those.
yeah,
Okay.
because we'll give him a copy of the conditions now.
Okay.
So they just feel free to let her, whatever date you get,
Okay.
after
And
he
then
gets out,
once
just
it's
get, yeah.
Okay.
I'm here for Francisco Hernandez.
Okay.
He's here for a bond violation.
Okay, come up, Mr. Hernandez. It's Hernandez or
Mr.
Roxanne? What the
For something positive for THC.
That's it.
That's it.
Okay. I'm giving you a pass for 50 days from the time that we ordered you not to use. Don't use. Do you understand? So we ordered him not to use when? He's still testing positive. We ordered him not to use in January.
Well, he tested positive on April 7th, Judge, or not, on April 14th, rather.
Okay, but he's still testing positive. He's still using when we ordered him not to use.
Yes, Judge, but I understand that THC can take up to 30 days to work out of urine, so there's no evidence that he's been using beyond the,
I ordered him not, let me see, hold on. I ordered him not to use in January. We are now,
Yes, Judge, but you've already addressed his drug use that resulted in the positive result on the April 14th drug test. You addressed that by chastising him in court and issuing several additional bond conditions. There's been no evidence that there's been any additional drug use for the court to address.
if I tested him in early January, then I'm gonna have an issue. But if it's the first time I tested him was in April, then I'm gonna give him the 50 days from the first time that we tested. But if I tested him early on and he tested positive and I admonished him not to use and he's still testing positive, I'm gonna have an issue. I don't remember when the first time we tested him, so I'm gonna ask her. Roxanne, on Mr. Hernandez, when was the first time we tested him, please?
When he first tested positive for THC?
Yeah, when did we first test him?
Oh, it was March 11th of this year.
So March 11th was the first test, and that was positive for,
Negative.
that was negative.
Yes, it was negative. And then on April 7th is when he was a no-show. And on April 14th, it was confirmed by lab that he was positive. for
No,
THC.
you're using. I'm sorry. I'm revoking your bond. You're going into custody.
I could just ask the court Mr. Hernandez's mother is out in the hallway. I'm certain that she's going to pay whatever the bond is. This, revoking the bond here will only have the effect of punishing, his mother who will have to pay the bond. And I'd also just ask the judge, you to consider that I understand that there may be evidence that he's used since he was ordered to not use. I understand that. But, there's no evidence that he's using now or that he has used in the more than 2 weeks since the prior drug test.
We just tested him yesterday. He tested positive. He tested positive a week ago. I've ordered him not to use. I mean, if I don't, then I'm rewarding him for his behavior, Mr. Schlossberg. That doesn't make any sense. You know, I understand that it's punishing mom. These are the things that you need to consider when you're out there. I told you not to use, and you're now using. Goes with you. I'm sorry, Mr. Schlossberg. I can't just continue to let people go.
Judge, the drug test yesterday, it came back positive for THC because it was within 14 days of the previous drug test on the 14th.
He tested negative the first time we tested him, and now he tested positive for using marijuana. That's it. There's no, I mean, really. If I don't, I'm enabling the behavior, and that's it.
Yes, Judge. Maybe excuse me.
Please. Good morning, Mr. Galvan. You were charged with driving while intoxicated. You were facing up to 6 months in jail and/or a $2,000 fine. Do you understand? Are you sure, or would you?
He's just a little bit embarrassed of the situation, Judge, of being here for the first time.
Do you prefer a translator, or?
Well, I understand what you just telling me, yes.
Okay, we are going to do probable cause. We need to know what happened in the case. You have the right to remain silent. Anything you say can or will be used against you. Okay, ready?
Yes, Your Honor, thank you. On April 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 74 miles per hour in a 45 mile per hour zone via radar. He observed the vehicle stop beyond the designated stopping point at a red light and make a wide right turn. The law enforcement officer initiated a traffic stop and observed the defendant to be the sole occupant of the vehicle. The law enforcement officer observed watery, bloodshot eyes, slurred speech, and a strong odor of alcoholic beverage. The defendant swayed while standing in place. The defendant's family showed up and stated they drove him home because he was drunk, and they found out he left again, so they went to the location of the stop. Standard field sobriety tests were conducted. A 6 out of 6 was reported on the HGN, a 3 out of 8 on the walk and turn, a 3 out of 4 on the one-leg stand. The defendant refused consent to provide a specimen, and a blood warrant was obtained and executed.
Any DWIs? Does he have a license?
He does have a license, John.
No prior DWIs, Your Honor. I'm running his license, although.
Mr. Galvan, I'm going to find that there's sufficient probable cause to go forward with your case. Hay suficiente causa para continuar con tu causa, ¿ok? No puedes tomar alcohol, illegal drogas, y te voy a hacer examen. Si tomas o si usas, te pongo en la cárcel. ¿Me entiendes? Tú tienes un abogado, no tienes que venir a la corte hasta que él te dice. Pero si él me dice que no puede contactar y tienes problemas, voy a revocar la fianza. ¿Me entiendes? Tú no puedes manejar si no tienes una licencia y también aseguranza en tu nombre. All right?
Thank you, Your Honor.
So, for now, we will have you sign a reset. Vas a ir con Roxanne de Pretrial Services y ya te puedes ir.
Y no se tiene que presentar para próximas cortes.
Muchas gracias.
You are Joe Castillo. Jose Castillo.
Sorry.
Castillo, you're charged with reckless driving. You're facing up to 30 days in jail and/or a $500 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 23rd, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle going 77 miles per hour in a 35 mile per hour zone via radar detection and weave in and out of lanes around 4 vehicles, nearly causing a crash. The law enforcement officer briefly lost sight of the vehicle, but found the vehicle parked sideways in a driveway close by. The defendant was still inside the vehicle and admitted to being the driver, but stated he was only going 60 miles per hour.
Okay. Mr. Castillo, I'm going to find that there's sufficient probable cause to go forward with the case. You run his license, please.
Yes, Your Honor.
You are not allowed to drive unless you have a valid Texas driver license and liability insurance in your name. Do you understand? That is a condition of your bond. I'm now also ordering you not to drive in a reckless manner, not to participate in any street takeovers, racing, anything of this nature. And if I find you do, I will put you in jail. No more PR marks. Do you understand?
It's other way, Your Honor.
How old are you, sir?
18.
What do you do for a living?
I work in a warehouse.
Okay. Do you have the ability to hire a lawyer? You want a court-appointed lawyer?
I'm gonna request an attorney.
Okay. I need you to fill out an application for me. Deputy Miranda is going to give an application. I'm going to have you go to Victoria, sign a reset, and then I'm going to have you take a seat in the jury box. Do not leave until you sign all our bond conditions. You understand? Come on. You mind filing those conditions, please?
Yes, Your Honor. That'd be no reckless driving and no driving.
Same as-
without license.
And then, no racing, street takeovers, donuts.
Yes, Your Honor.
You are Alexa Mendoza. Ms. Mendoza, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
Thank you, Your Honor. On April 23rd, 2025, law enforcement officers were dispatched to a traffic collision in Harris County, Texas. The officer observed the defendant's motor vehicle on the fixed rail tracks impaled to the LRV. The law enforcement officer opened the door to check on the defendant, the sole occupant of the vehicle, and observed the defendant to be impaired. The law enforcement officer observed glossy eyes and slurred speech, and the defendant stated she left a bar where she had 8 to 10 drinks of tequila and was on the way to a concert. Standard field sobriety tests were conducted. A 6 out of 6 was recorded on the HGN. The law enforcement officer notes that the defendant threw up during the HGN. The walk and turn was a 4 out of 8, and the one leg stand was a 3 out of 4. The defendant was ID'd by her Texas driver's license, and the defendant consented to a breath test yielding a .137 and a .123.
Any prior DWIs?
No, Your Honor.
License?
Check that.
Ms. Mendoza, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication. You will be randomly tested. If you test positive, your bond will be revoked. You'll go into custody. You understand?
Yes.
You are not allowed to drive unless you have a Texas driver license and liability insurance in your name. As long as you have those, you may continue to drive. Just don't use. Do you understand?
Yes, sir.
It is helpful, Your Honor.
Great. Because you have a lawyer, I will waive your appearance, but you must stay in touch with them and they'll tell you if and when you have to come back to court. For now, we'll have you get a Victoria sign a reset. You'll get with Roxanne for your bond conditions and then you're free to go.
Yes, sir. Thank you.
Thank you. Good morning, Mr. Royalty.
Yes, sir.
Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Thank you, Your Honor. On April 24th, 2025, a law enforcement officer was dispatched to a Shell gas station in Harris County, Texas. Upon arrival, the officer observed the motor vehicle to have crash damaged and to be disabled and inoperable. The law enforcement officer observed the defendant sitting in the driver's seat. The law enforcement officer observed constricted pupils, slow speech, and unsteady balance. The defendant stated that he was driving his vehicle before the accident and that he does not know what he wrecked into. The defendant stated he did not know where he was coming from before the crash. The defendant stated he consumed 1 alcoholic beverage. He also stated that he inhaled nitrous oxide approximately 20 minutes before the crash. Standard field sobriety tests were conducted. A 0 out of 6 was recorded on the HGN, a 3 out of 8 on the walk and turn, a 2 out of 4 on the one leg stand. The law enforcement officer observed an empty bottle of vodka on the driver's side floorboard, an empty vodka bottle inside the center console, and a half-empty beer in the back seat. The law enforcement officer observed 3.3 liters of space gas containers of nitrous oxide and 14 1-liter nitrous oxide containers. The defendant is a registered owner of the motor vehicle. The defendant agreed to a breath test strip. However, the law enforcement officer notes that there was an interferent error and the breath test was unable to be collected. The law enforcement officer called for a drug recognition expert who completed an evaluation. The drug recognition expert stated the defendant is under the influence of cannabis and is unable to operate a motor vehicle safely. The defendant consented to a blood test and a sample was collected.
Okay. Mr. Royalty, I'm going to find that there's sufficient probable cause to go forward with the case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, unprescribed controlled medication, and that includes nitrous oxide, whippets, anything of this nature. Do you understand?
Yes, sir.
If I find that you use, I will revoke your bond, put you in jail, no more PR bonds. Any priority to DWIs?
No priority to
License?
eligible.
And you may continue to drive as long as you have a license and liability insurance in your name. If you don't have either, then you're not allowed to drive. Do you understand?
Yes, sir.
Do you have the ability to hire a lawyer? Okay, I can have you fill out an application. We'll take a look to see whether you qualify. I need to know everything about you, how much money you have at the bank, what you do for a living, what kind of car you drive, how much money you have coming in, and I'll take a look to see whether you qualify. Deputy Miranda's going to give you the application. I'll have you sign a receipt with Victoria, and then we'll have you take a seat in the jury box, sir. Sir, please. Why does this keep happening? Over and over and over. Why does this keep happening? How many cases did you have last year, Mr. Addison?
I have quite a few, sir.
Now, it pled on the 17th of December, and not 3 weeks later, you have now another criminal trespass. How do we stop this from happening?
You need to leave Texas?
No, we don't want you to leave Texas, but we want this to stop happening. Why would I keep doing this?
Officers don't like me out there, man. They be harassing me. They beat me up. They assaulted me. They put me in the hospital. They tried to kill me.
So why go back?
What do you mean?
Why go back to the same location over and over if you know that they're going to beat you up?
I'm of the state of Texas, not just this area. The state of Texas, the laws don't like me. The police don't like me, sir.
That's baloney because you're a likable guy. We all like you, Mr. Addison. You seem like a stand-up guy. You're nice, but you keep going back. Why would I keep doing this? You know, we hit you with the time served. We let you out. 2 weeks later, you pick up a new case. And it's been like that for the last damn year. Where's your family? Who do you have in your life?
I don't have nobody in my life, sir. All my family is dead. My twin just died not too long ago.
You got no kids?
But they grown, yeah, but I can't find them.
Why not?
Because their mother hid them from me.
You ever tried to find them?
Yes,
How?
through the internet. Through the internet, sir.
I don't know, Lori. We're doing the same shots over and over and over. And last year, 1, 2, 3, 4, 5, 6, 7, 8, 9 cases just last year. You pled at the end of December. January, you've got a new case. We let you out. You took off on us 2 more times. And the only reason we have you now is because you picked up an interference. And now we're doing the same thing over. I'm not going to do this. I'm done, Mr. Addison. I'm not going to continue to do this. Plead you to the time served in hopes that you're going to go out there and not do it. No, it's not going to happen. We need to figure something else out. Thank you. That's very sweet. But I'm not going to do this. We need to do what I'm going to do now, what's called a TRAS, to see how we go forward. Because I don't know enough about you and what's going on in your life to figure out how we go forward so you stop picking up criminal cases. I told you that many moons ago that I'm going to stop doing this. And now is the time. I'm not doing it, Mr. Addison. We will set this case for a TRAS. I'm going to try to expedite to get it done as fast as we can. I'm done. What I'd like to do, and the hope is that somehow you, me, and Lori can figure out what kind of family you have in the United States so that we can get you somewhere where you stop getting in trouble. But it's not working what we're doing. And I'm not going to continue to, this is not a revolving door. Do you understand, sir?
Yes, Your Honor.
That's what we're going to do. So Lori, I'm sorry, but let's set it for a TRAS.